Hey guys, good morning. Scott Buda from Learn to Real Estate. We're going to be continuing on some flashcard in the contract category. Okay, and I'm not doing an overlay with myself in there just so I can try to get through this video a little quicker on processing. What is meant by latent defect? Okay. Latent defects. We know it's a defect and it's latent. Latent defects are the flaws that are hidden but are likely to surface later. Latent defects are an exception to the principle of caveat emptor. For example, a building is found to have latent defects in the form of poor construction of subfloor and improper foundation support. If the defect was not disclosed to the buyer before purchase, the seller may be liable even if the buyer bought the property as is. Remember the term there, may. If nobody had awareness of anything, then you're pretty safe. Okay. What are hidden defects? Hidden defects is one that is not apparent from examination of public record or without invasive examination of the property. For example, a secret marriage, forged document, or the fact that a prior grantor was a minor are some causes of hidden defects in a title. A hidden defect may also be physical, such as an underground environmental contamination. It may also be called a latent defect, as we just went over. What does it mean? What does as is mean in a contract? As is means in its current state or condition without any guarantees. This phrase may signal a problem. Premises are accepted by a buyer or tenant in their current condition, which may include physical defects. For example, if a buyer purchases a building as is and then later discovers that the roof leaks, the seller is not legally responsible for repairs. As is. You can use that for a lot of things, as is. Okay, what do we have? We have, what is escrow? We've heard that term. Monies are put into escrow. There's a nice thing on it here. Escrow, or an escrow contract, is an agreement between two or more parties providing that certain instruments or property be placed with a third party for safekeeping, pending the fulfillment or performance of a specific act or condition. The most common use of escrow in real estate transactions is for the earnest money deposit, which the broker must place in a separate checking account until the contract is either fulfilled or expires. If the contract is fulfilled and the sale closes, the seller receives the deposit. If the conditions of the contract are not met, the deposit is refunded to the prospective buyer, provided the contract doesn't state otherwise. Okay, there's your escrow. What is a deposit? Putting money down on something, kind of a tie-in. There's a good amount of things here to tell you about it. A deposit is called earnest money. That's a key word, earnest money. It's also a deposit. Is money paid in good faith to assure performance of a contract. Deposits are commonly used with sales contracts and leases. If the person who put up the deposit fails to perform, the deposit is forfeited unless conditions in the contract allow for a refund contingencies. Brokers must put deposits in a separate checking account pending completion of the contract. Brokers must not commingle their own funds with client money. Very important. For example, Elizabeth presented a $1,000 check for the earnest money deposit on a home she would buy, provided she could get a 30-year loan at 5% interest for 80% of the purchase price. The broker deposited the check in an escrow account and refunded it when the contract was terminated because Elizabeth could not arrange for the loan. Very common. Everything on contingency. If you're a buyer, make sure that you want the purchase to go your way. Okay. Can a seller who is under contract of sale prepare an amendment, for example, to delay closing by a week? Okay, so if you look at the question, can a seller who's under contract of sale prepare an amendment, for example, to delay closing for a week? And again, the thoughts are as long as both parties agree. And we have a very short answer here. For an amendment to a contract to be binding, both parties must agree. So an amendment can take place in a contract as long as both parties agree. Okay. Is an amendment to a contract the same as an addendum? Amendment is mending. Addendum is adding. No, usually addendum is prepared with the original contract, while an amendment is a later change. So you can amend a contract by adding to it, and addendum is an original part of a contract. And is the amendment to a contract the same as an addendum? No. Making progress here. What is an amendment to a contract? Okay. An amendment is a change, correction, or extension of an agreement. That does not change the basic thrust of the agreement. All right, so it's an add-on. For example, lease amendments might be used to renew the lease for an additional term, change the percentage rent requirement, or clarify the tenant's defined parking area. So it's an add-on. Think of an amendment as an add-on. And here's our other friend. What is an addendum to a contract? How these all tie together. Line this up for us. Okay. An addendum, plural, addenda, is something that is added as an attachment. Another word for this is called a rider, and riders are common. Some commonly added addenda in real estate purchase agreements are for financing terms, the property inspection requirements. Okay, so an addendum is something that is added as an attachment. It's not amending the current contract. It's adding to it in a separate attachment, considered or called a rider. Commonly, addenda or agreements, purchase agreements, are for financing terms and property inspection requirements. Okay. What is a rider to a contract? Well, we just went over the addendum, so it's an add-on. Right? Rider is the same as addendum. It's an addition that rides along with the contract. The term rider is more commonly used in connection with insurance policies, which often include riders to insure specific valuable property. So you'll have an insurance policy, and then it will have your riders such as jewelry, silver, antiques, or art objects against loss. Okay. And one more here. What is the meaning of time is of the essence in a contract? Time is of the essence. Very important in closing. Everybody has to come together. Time is of the essence. You have a nice little understanding of it right here. Time is of the essence is a phrase commonly inserted in contract. Its effect is to require that all specific dates and times referenced in the contract be interpreted exactly. In the absence of this phrase, delays might be acceptable. For example, a contract that states that time is of essence may require a very strict interpretation of the time provided for the buyer to arrange financing and the date set for the closing. If these terms are not met, the other party may assert that the contract is void. Time is of essence. Okay, guys. Hey, I appreciate you stopping in. We got a lot more to go, and I'll get this published, and we'll get on to the next contract. We have 022. This will be published under. And have a good day. Take a break and be back. Thank you.